God bless you. I am live. Anna Kate here. We are live on YouTube and on Twitter. I am currently banned on Facebook for like the millionth time, but that's okay. We have on today an update on this big tech lawsuit that Congress is now looking at and is very interested in. We're going to talk about why the First Amendment lawsuits are not working against big tech, and why we think and we believe, and I should say Jason Fick and his lawyer, Jeff Graber, who are joining us here today, why this case has legs and why Congress is paying attention to it. He just filed the lawsuit in the Ninth Circuit Court on March 3rd. So we're going to get an update on what's going on and why we think this is like an amazing case. So praise God. Before I do, I want to say a quick thank you to the sponsor of this video, Noble Gold. Thank you for supporting this channel. If you're looking for an IRA or 401k, look into Noble Gold. Precious metals is the way to go. I have my own gold as well. I'm actually also buying silver very soon because I heard that's going to really go up, especially with their plan on the Great Reset. So that being said, go on over to noblegoldinvestments.com for more information. Without further ado, let me get Jason on, and also Jeff is on the line. Jeff Graber. Hey there. Hey,
hi, how are you?
I'm good. Hey, Jeff, can you hear us? Perfect. Okay, so we are both on the line. We are live right now. Good afternoon, everybody watching. JP, thank you for moderating. So you filed on March 3rd. Congratulations. This is an exciting case.
Well, we filed the second appeal. So there's two congruent things going on. Just to give you a quick update here, we filed against Facebook back in 2018. We took it all the way to the Supreme Court and technically lost. That's what we had discussed before. And when we lost, it sort of put us on two different paths simultaneously. Right after all of that happened, another case turned out that we were right. We were right from the very, very get-go. And that's actually one of the things we can discuss today, which is the perception that Section 230 allows everything. It doesn't. Actually, the fundamental question we have to ask is whether or not the site acted as a good Samaritan. We'll talk about that in a minute. But we filed our second appeal in the Ninth Circuit Court, and our question is very, very narrow now. And it only really asks, does the Good Samaritan provision of the Communications Decency Act, because it says it right there, Good Samaritan, does it apply to the entire statute? Well, of course, logic says, of course it does. They have to be a Good Samaritan first. So that is what is currently in the Ninth Circuit, the Ninth Circuit right now. A question for them on my personal case. However, what we had talked about before, which is the constitutional case, we are getting very close. And we have Jeff on today, which is great. My one of my attorneys, and we are working towards filing probably one of the most monumental cases in modern history. It is a case questioning everything, all of it, the whole Section 230, whether it was constitutional, and as you said, the First Amendment. Although there is a First Amendment claim, we are going to be bringing and advancing a First Amendment challenge. The Fifth Amendment, I believe, is stronger, at least in our opinion. And there are a lot more challenges in that direction. That's coming soon. That is what we have congressional attention on now, because they've read some of our actually, believe it or not, we broke it on your show. That executive summary, that was the first iteration of it, and it's caught a lot of attention internally because they realize some of our arguments are on target.
Yes, and we actually, so if you guys want to check that out, we did talk about this file last time on the, you can check out on YouTube. I think it's also on Rumble as well, where Jason goes through the lawsuit and what it means about having a Good Samaritan clause, which apparently, quote unquote, big tech thinks that they fall under, right? And they actually don't. And so that's what he's going to prove. And that really makes it something that Congress can pay attention to, because that's something that conflicts with the clause. So let me go back to, why is it that the First Amendment lawsuits aren't getting heard as well as maybe your case? Well, actually, you're appealing it now, but with the First Amendment lawsuits, why were they having trouble? Why were they always dismissed?
Well, in the First Amendment situation, let's separate the two issues. There's one where my personal case comes down to money, right? It's the free market. In that circumstance, they clearly can't be a good Samaritan if they acted on their own behalf. That's my personal case. That would resolve certain aspects of it. As far as a First Amendment challenge, that's something that's a little more difficult, and I'd actually like Jeff to field that question because he is one of the lawyers representing me and has stuck with this. And I have to say this just ahead of time. Jeff Graber has been there for years, fighting this incredibly hard when there's a lot of opposition to us. So, Jeff, I need to feel that call, the strength of First Amendment versus the Fifth Amendment. Can you hear us, Jeff? I'm not sure we can hear him.
Unfolding is your Fifth Amendment due process rights, which is squarely at the center of our prospective constitutional challenge of Title 47 United States Code Section 230, the Communications Decency Act enacted in 1996. The deprivation that Jason has experienced by way of his due process rights has been uniform from the get. As Jason said, we launched his personal case against Facebook in 2018, squarely addressing economics, really. Facebook overnight at the press of a button crushed his livelihood. We had 4 causes of action: fraud, civil extortion, anti-competition, and tortious interference with economic advantage. And, he never got his constitutionally guaranteed Fifth Amendment due process rights in the Northern District of California Court, the Ninth Circuit Court of Appeals, the Supreme Court of the United States, because they snuffed him out at the threshold under this crazy concept that big tech enjoys carte blanche immunity across the board for any and all actions they take in the magical ether of the internet, no matter how otherwise illegal it would be outside of that ether. Plainly, any type of immunity that is going to quash a citizen's due process rights is constitutionally repugnant. There are several other angles of the prospective constitutional challenge, but Jason's absolutely right that the biggest constitutional protection being deprived by the way too overbroad immunity being vested in big tech is the Fifth Amendment due process right.
Amen. Got that. So what makes your case different? I know that Jeff just explained about your case, but what makes it different from every other case that has been brought forth?
Okay. So obviously, and I'm actually going to digress a bit here. Section 230 is complicated. We all know that, right? It's been around since 1996. There's been a lot of cases, a lot of lawyers, a lot of people think that they understand it and they don't. We have done an incredibly comprehensive, deep dive into this, going all the way back to the form and function of the law and so on and so forth. So to answer your question, I'm going to walk you through in simple terms as to what happened. So essentially what happened is that these sites, many of them, Google, Facebook, Twitter, and so forth, they create a platform and they want engagement. They want people to join, right? When people join, they eventually hit critical mass when they have just a ton of people, right? And when they hit that point, they go, okay, well, let's just switch our whole game around. And that's what Facebook did to me is they switched to an advertising business program that's directly at odds with its own users. Now, the reason I say that is because if they're offering you reach and distribution to join their site, and you're using that reach and distribution organically, and then they turn around and they want to sell it, they want to sell distribution and reach, they essentially have to shut you down in order for them to make more money. And because they have control over the site, they're illegally and unlawfully claiming that it's offensive content when it's really not offensive content. It's objectionable in the sense that it makes somebody else money, not them. So their whole business program Their whole advertising program is at odds with its own users. Now, what happened was I was very large at the very beginning of this game. We were way back in the day, and I had millions upon millions upon millions of fans, and I actually was making a lot of money from it. And they needed to shut me down. And I had caught them red-handed. Essentially, they shut my content down, saying it was offensive in some way. And then another business partner, but it was still a competitor, asked to get my stuff reinstated. And they reinstated it for that company, but they wouldn't do it for me, meaning the content was never the issue. And our lawsuit was never about content. And that's where the courts have been making the mistake over and over again, is they're saying it's a content case. No, it's a conduct case. What did they do to me? They took my content down for their own nefarious purposes, which is, it's antithetical to the idea of a good Samaritan. You can't be a good Samaritan helping others if you're taking money. It's just not the way it works.
Mm.
And the other case, this is on my personal case, the other case, Enigma versus Malwarebytes, they prove that Good Samaritan applies, that you have to be a Good Samaritan first. Why? Because it's right at the top of the heading. It's protections for Good Samaritan blocking and screening of offensive materials. It doesn't say protections for any publishing act that they want to do. That's just ridiculous, right? It's absurd. So we are challenging that, and it has, I mean, realistically, what's happened to me is completely unjust. I should have been in the courts a long, long time ago. And for people that don't understand, we're at dismissal stage, meaning courts haven't heard me. They haven't even listened to anything yet. There's no merits whatsoever because we're on technicalities that are wrong. And that's what our Ninth Circuit is now challenging and saying, look, you have to be a Good Samaritan first. And that would change a lot all at once. Because guess what? There's your first question. Did they act in the interest of others for the public? If they can't meet that, they're thrown out.
Yeah. So let's back up. Let's explain that, because, we're talking about the Good Samaritan, but what is that exactly? Let's go through the clause and then talk about, obviously we know that Facebook, Twitter are not Good Samaritans, right? YouTube, they're banning people, like livelihoods, like you and your business. Candace Owens was knocked off monetarily. I've been knocked off YouTube and Facebook monetarily as well. That's fine because I have other ways to make money. But some people, that's their entire business is on Facebook. Right. So let's back it up. Let's talk about the Good Samaritan really quickly. I know we went through it last time on YouTube, and surprisingly, that video is still up. So I think it's on Rumble as well, but you guys can watch the full video where he goes through it. This is a video that Jason is showing congressmen, that Jason is showing others, where he walks through the entire clause, the entire lawsuit. So make sure you check that out. But just walk us through a little bit about the Good Samaritan clause for people that have never heard of it before.
Jeff, do you want to field this one?
Sure. I'd be happy to. So, again, the law at question is Title 47, United States Code, Section 230. There's several subparts to 230. The subpart that is the focus of everything going on with Jason Fick's private case and the prospective constitutional challenge is subsection C. C is in Charlie. The very title of subsection C speaks to Good Samaritanism at the threshold. It is right there in quotation marks. That is called an intelligible principle, a general directive, a general principle passed down by Congress when Congress is looking to delegate regulatory actions of sort to another party. In this instance, the delegation of internet policing to big tech. So Congress is telling big tech right at the start of Section 230, before you get into C1, C2A, or C2B, and all of those C's, by the way, speak to the different instances in which big tech should appropriately enjoy some immunity. But before you even break down those three subparts of C, you had to first be acting on another information content provider's materials in a Good Samaritan way. Now, the Enigma case that Jason speaks of addressed 230C at the threshold. And there, Enigma was arguing that Malwarebytes had messed with Enigma in an anti-competitive way. It's called anti-competitive animus, which is precisely what Jason Fick argued with respect to Facebook. Heck, it was one of the causes of action, California's unfair competition code. Now, the Ninth Circuit in Enigma, and then it went all the way to the Supremes, and the Supremes endorsed the Ninth Circuit decision with Justice Clarence Thomas doing something basically unheard of, issuing a 10-page statement, which I consider an advisory opinion, as to what Section 230 immunity should look like and how it's been abused over the 26 years of existence. But they went on to find that Malwarebytes acted against Enigma in an anti-competitive manner, and anti-competition is the antithesis of Good Samaritanism. Good Samaritanism and anti-competition are oxymoronic. Mm-hmm. They cannot coexist. Now, Enigma was served up some justice there because Malwarebytes was not found to have immunity. The courts didn't really even go on to thoroughly assess the Section 230C subsections because they stopped at the Good Samaritan threshold and determined that Enigma's complaint survived dismissal because Malwarebytes could not enjoy any sort of immunity if they were an anti-competitor out there to augment their corporate bottom line. That's precisely what Jason argued against Facebook, and yet somehow his case, his individual case, has enjoyed or not enjoyed a different fate. He's been deprived of his due process, and that's what we have up on the second level of appeal.
And now that's why you're able to bring forth the Fifth Amendment, correct, with this appeal, which now you're not just talking about the First Amendment, right? You're bringing in the Fifth Amendment. So explain that and why you actually have grounds in a way to really get traction, which is why Congress is interested now in looking into this, as Jason and his lawyer Jeff Graber are talking to Congress now, and they're very, very interested in this case because unlike everyone else with the First Amendment that keeps getting dismissed, you actually have another amendment as well that stands stronger ground. So explain the Fifth Amendment appeal now that you just filed.
So the prospective constitutional challenge, Jason, vis-a-vis his individual case, really does have pure standing. Section 230 harmed him badly. The overreach of immunity afforded to Facebook deprived him of his constitutionally protected due process rights under the Fifth Amendment. So the prospective constitutional challenge not only is coming at 230 from a direct constitutional repugnance, Fifth Amendment being one example, really the central example in our thrust, but also this law, as you will see in the prospective constitutional challenge, it is void for vagueness. There's so many canons of statutory construction, constitutional doctrines that it violates. I'll just rattle through them. Void for vagueness, surplusage, the whole reading canon, the absurdity canon, the irreconcilability canon. The list goes on and on and on as to how messed up this law is from a constitutional perspective, not just from the Fifth Amendment viewpoint, but all of these various canons and constitutional doctrines. So this prospective challenge, Anna, it's not just the Fifth Amendment. There's several pieces to it.
Yeah, I'm reading this right now. Furthermore, Section 230 is an immunity from suit, right? So the immunity of the sovereign is recognized with regard to sovereign or public acts of a state, but not with respect to private acts. In other words, states hereby, private entities should enjoy immunity from suits arising out of the exercise of their governmental functions, but not from suits arising out of the types of activities in which private parties engage. And so,
so that's violative of the non-delegations doctrine, the major questions doctrine, which Justice Gorsuch, as well as Alito and Thomas, recently brought up in the OSHA vaccination cases. It's very interesting, very deep as to how messed up 230 has become. And, you know, this constitutional challenge is going to address it from every aspect.
And if I can inject this real quick, Anna,
Yeah.
the point is that we, unlike everybody else that just superficially sloughs this off with saying, well, it's, you know, it's their First Amendment right, they can do whatever they want, it's private activity. It is not. It is a delegation of authority. It's the structure of the law. It's what we went through last time, which is they are given a delegation of authority. That authority, they've gone way beyond the bounds of that authority, what they consider overbreadth, and we have comprehensive. I can't even tell you. I mean, I know Jeff can agree on this. The amount of hours I've spent in this personally, thousands, because I know the ramifications here. The ramifications aren't just my personal case. If we don't do this, who will? And if we don't do it now, when? I know there's a very famous quote around that, but that's really the point. I mean, we're going to lose our First Amendment rights. We're going to be controlled by a fourth branch of government, otherwise known as big tech. And that is, you know, why we're getting support now, because there is no way to make Section 230 functional. We don't believe that there's any way for it to stand.
Right. I mean, listen, they kicked off the president of the United States off of Twitter. And the thing
not
is,
Putin.
And not Putin.
Not Putin.
Right. He was attacking family that I have in Ukraine.
That's scary.
It's very scary. And not kicking off pornographers and porn that I see all the time. But meanwhile, they kick off the president of the United States. You know, people are losing hope. People are losing hope because we saw President Trump have a lawsuit as well, a class action lawsuit. And it's really not getting much ground. I don't know how it stands now. I'm not sure. I haven't followed it much closely in a while. But, you know, people are losing hope. And you have Congress now that are interested in this case. Can you share anything about what Congress and why Congress is interested and who there is interested? Are you allowed to name drop anyone?
I can't name names yet, but I can say that we have a true patriot, American congressman, who was an attorney and potentially a judge. Won't go into too much detail, but they have looked at our executive summary. They've gone through some of the doctrines and the canons and so forth, and they're in concurrence with us that we have the grounds for a constitutional challenge, and they have already expressed a lot of support. We are looking forward to working with them. Their counsel, you know, because of course they have internal counsel as well, has also looked at this and is also in agreements with us, because they're not looking at it superficially. They're looking at what we've looked at, which is the comprehensive version of this as to how it was basically put together and what happened. And it will be an interesting challenge, because if we have congressional support, we're essentially challenging Congress's own law. And we have Congress saying, yeah, these guys are right. It'll be a different approach altogether, because I believe, you know, this may, by the time we're done, strike Section 230 entirely, or at least sever a piece of it, which would be the piece that allows them to restrict access to anybody's content without virtually any, any reprimand whatsoever. You can't even get a court date. So that's where we're heading right now. Can't say who, but I can tell you that many messages have gone back and forth, and there is, the rally of support that's going to be coming, I believe, on this one.
Yeah, and it's exciting because, again, you have a different cause and a different, I'm not a lawyer, I don't know how to say it exactly. Different approach than the First Amendment, right? You have now the Fifth Amendment that they did not hear your case. It wasn't constitutional. And again, taking it from a different perspective using the Fifth Amendment, correct?
Keep in mind something, Anna. And I think Jeff will be with me on this one. So constitutional doctrines, right? They have two different ways that they can be challenged. They can either be done as applied or on their face. Okay. So if something on its face means it's just blatantly right there, you can't do it, that's on their face. Or as applied means that as the companies or commissions or whoever is imparting those laws is using it differently than what it was intended to be, then it can be as applied. So there's two different functions for each doctrine.
I see.
We have 4 different doctrines, both on their face and as applied. So there's 8 different ways alone that Section 230 can be changed. And then on top of that, we have 5 other canons of statutory construction. So there are 13 different ways that this could be stopped, struck, changed, or modified, or explained. One way or the other, it will push the courts to do something. And something is better than what we've gotten so far, because we've gotten nothing. And in fact, and actually I'm hoping that maybe somebody gets this. Justice Thomas, he asked for the appropriate case in the Enigma versus Malwarebytes. We are bringing the appropriate case. It is a fully comprehensive explanation of everything with regards to Section 230.
Yeah, we believe the constitutional challenge is a case of first impression, and that's bolstered by Justice Thomas's 10-page statement in Enigma, whereby he said, in the 26 years or so that this law has existed, the Supremes have never had a real opportunity to tell the world what it's supposed to be, how it's supposed to be applied. The immunity is so simple if distilled to a commonsensical functioning dendrites, firing synapses level. Jason, on prior broadcasts with Anna, have you gone through what C, C1, C2, and C2A and B are supposed to be?
I have, but I will say this. This audience has probably not seen that. And believe it or not, Anna, we have actually rendered this down to its absolute elemental parts. There is no other way that it makes any what they call harmonious sense, right? So when you read a statute, it has to be read as a whole, all together, and then it has to harmonize, meaning they have to all work interchangeably. Otherwise, the law doesn't make any sense. You can't have repetition or duplication, right? And it comes down to this. There are essentially 4 parts, and it works like an outline. For those of you that are out there, think of an outline, right? And you have C, right? We're talking about 230C. Because I don't want everybody to get confused. 230C is what they call a title. It's the long title. It explains what Congress wanted done. And that is to protect good Samaritans that block and screen offensive materials. Now, offensive in the eyes of the government in 1996 is different than what they're trying to say it is now. It was mostly to do with sexual content, almost all of it. Believe it or not, that it's what they call impermissible. Now, there were other things like defamation and harassment and so forth. So that said, the next part down is 230C1, right? It's the first one. First one says it can't be treated as the publisher. Now, what does that mean? It means that they're not the publisher, that they had nothing to do with the content. They never acted upon it. And that was actually messed up as far back as 1997. There is no action involved in 230C1. It's where they fail to act. It's where they omit action. The next one is very simple. It's when they take action. And they take an action to restrict the offensive content. And it gives them specific governmental guidelines as to what actions they can take. They can go after harassing information or otherwise objectionable. And it is incredibly overbroad. But that is the directive from Congress. This is how you can take down information. And they're protected in that circumstance. And the last one is essentially, it's a little bit different. It says that they can take action, but not on content. It can take action in the sense that it can give others, like you and me, the tools to act on our own behalf. So they can do something, but it's not on content. It's just purely to give you the tools. And that is how it would harmoniously read if it were applied to its simplest form. But that's not how it has applied in the courts, and that's what we're trying to sort out and straighten out for the first time. Really, the courts have not fixed that.
Yeah, and actually, Paco, man, asked a great question. What are you hoping this lawsuit will accomplish? Great question. We kind of talked about
Jeff,
already.
or do you want me to handle that one?
Well, how about social media freedom? How about not infringing upon constitutionally guaranteed rights? How about restoring the CDA to its initial good purposes? Which, as Jason said, in 1996, heck, there's nothing legal about this. Just read Wikipedia and read the 2 congressmen that enacted it in 1996. The purpose was largely geared towards eradicating pornography to protect our children.
Right.
And it's spiraled into this, I think you said, Anna, quite appropriately, really a sovereign immunity of sorts, whereby big tech thinks they're invincible for any type of illegal conduct that they may engage in. So,
you know what?
I mean,
I want to stop right there and say, you guys, like, that is the reason why big tech, that was the first point that big tech was able to start banning people, because of pornography. When you go on Twitter, there is so much pornography. So they've kept the pornography, but they kick off the conservatives and any narrative that goes against the agenda. The push agenda. So
to simplify, Anna, realistically, what we're looking for is either the courts or the Supreme Court to narrow this. The existing version, harmonize it and narrow it. Now, we don't believe that it can actually be harmonized ever. It actually has internal flaws with regards to the canons of statutory construction. But let's set that aside and let's say that they just try to do the best that they possibly can with what they currently have, right? It is narrowing that field down to what it was elementally supposed to do. That there is supposed to be some version of good faith in there, that there is supposed to be some version of good Samaritan in there, and that the laws don't allow this sovereignty anymore. So our hope is a narrowing, which would be what's called declaratory judgment, okay? Or on the flip side, there is the possibility of severing a piece of it, because 230C2A just can't stand. It is unconstitutional. There's no way 230C2A can stand at all. Sever that piece out, maybe, because everybody says, well, then they'll be charged with, you know, publication of everything that's on there. No, I don't think, if 230C1 were interpreted correctly, not the current version, because the current version is editorial function. It's everything, right? It's basically sovereignty in and of itself. That has to be sorted out first, and then it becomes that they can't be held accountable for something somebody else did somewhere else, and not what the courts think is that they can't be held accountable for their own. That's not how it works. If that were fixed and 230C2A were severed, it would work. They're not responsible for what somebody else did, and they can't take. Now everybody says, "Oh, well, then it'll be a cesspool." No, it won't. Here's the thing: a company is still they're incentivized to provide a good site, right? So they're still going to want to take down anything that is offensive or bad, really bad. That doesn't mean you can sue them. If they took down my content because it was offensive, I might not have the grounds to sue on, right? Because you then have to go to the merits of the case and say, well, why did they take it down? Mine was obvious. It was unlawful. They did it for money, and it was right on its face. You could tell that. It doesn't mean everybody can sue them just because they take down content. They'd have to do something that broke the law. If they discriminated because you were, you know, of the wrong gender or the wrong, you know, color, that's unlawful. They can currently do that.
It goes into a good faith analysis. Like I'll give Anna and the viewership an example. One of Jason's multi-million fan Facebook businesses pages, he posted a screenshot from the children's movie, the Disney Pocahontas movie. They crippled him overnight, Facebook, claiming C2A, that was somehow racist. I mean, it's spiraled out of control. But what should have happened there is, and the district court deprived Jason of this, deprived him of his due process rights. If a big tech, a Facebook, a Google, a Twitter, cripples someone like they did Jason over supposed filth under C2A, it's not dismissal fodder. It goes past the pleading stages of dismissal, and you actually get into the facts. You actually get into the merits. You actually assess whether or not Facebook's crippling of the Pocahontas screenshot page was done in good faith. And because Facebook knew that the good faith analysis is not dismissal fodder, and they would have gotten into dangerous discovery territory with us, they just rewrote history and tried to bundle all of their actions or whatnot against Jason under C1. Completely rewrote it when it was really C2A based at the threshold. But, you know, under C2A, the whole point is, as Jason just said, you get into the facts.
Right.
You know, Jason's given his day in court to actually assess whether or not Facebook's actions were done in good faith. He was deprived of that. It was ridiculous. C2A has spiraled out of control along with the entire Section 230.
100%. I mean, listen, it's like having Twitter take you down because your followers are maybe bad people or they write bad things. That's not, it's not. I mean, this is separate from what you're talking about, Pocahontas. Like, for example, with President Trump, the reason why they took him off is because he might have led some people to do an unpeaceful rally, which again, most of the rally was peaceful. For example, with Milo Yiannopoulos, they took him down not because he committed any crime, but because his followers were saying nasty things on Twitter and which again isn't a crime to talk about someone's looks or whatever, unless you're doing an actual crime where you're actually,
inciting violence.
And
I will say, let me point out the irony here, just so everybody understands the irony of what you're saying. The social media company is not responsible for what someone else says, but they're holding people accountable for what someone else says. Interesting. That's exactly how groups work on Facebook. If somebody else in the group posts something bad, the whole group gets penalized, and including the admins. So they're getting held accountable, or they're actually being treated as a publisher.
To allow the Facebooks, the Googles, the Twitters, the YouTubes of the world to control thought, ideologies, politics.
Say that again. Which one?
Religion.
Say that again.
Economic livelihood. And that is precisely what it's become. They are the arbiter of truth. They are the judge, jury, and hangman. It's crazy.
That's right.
What he's talking about, Anna, is we will have a First Amendment challenge under this as well. And it is something called the substantial overbreadth challenge, BREADTH, right? There is a breadth to which Congress enacted this law, and it said to, block and screen offensive content. And it has morphed into any content. It has morphed into this perception that they can take down thought or anything that they simply object to for any reason. And that is way beyond the breadth. And see, the way a substantial overbreadth doctrine works is that if the substantialness, meaning the amount of information that is taken down of permissible speech, meaning you're entitled to your opinion even if it's hateful, but it's permissible. So in the scope of the government, what is impermissible? What is determined to be absolutely patently offensive? If it exceeds that in a substantial manner, which we know it does, because it's virtually everything, then it's overbreadth, and it can be taken down just on that challenge alone. So that is a First Amendment challenge.
Got it. Barnes asks a great question. How much do you expect this fight to cost you guys? And, what can the average citizen do to make a stand and help?
So it's a great question. I have thrown everything at this. Everybody comes out there and they're complaining about the world and be a patriot and do what you can and so forth. I did that. I put my money where my mouth is. I have thrown absolutely everything at this thing. I know that Jeff has put in a ton of time. I know Connie has put in a time. Some of my other lawyers, we have thrown everything. Why? Because we know we can fix it. If the courts give us the time to make them understand what we understand, there is no way that this law will stand. There's no way. So in that circumstance, we formed something called the Social Media Freedom Foundation. And you can actually go to our website, socialmediafreedom.org, okay? And on there, you can help us. You can help us stay in this fight because I'm in it till the end. Whether I go broke, bankrupt, or whatnot, I am in this till the end, one way or the other. Will it help us? Yes, because we have a much better chance at beating them because this isn't a game, and we are legitimately trying to fight them to stop this. Otherwise, we're going to lose our country. Freedom of speech on the internet is predominantly, 70-80% of communications now is all internet. If they control that, our country's done. It's the modern day book burning. Like, we're in real trouble here. So we know that we can do this. We don't know what the courts will do. Obviously, nobody knows, but we can present it, and we have done the work. You can go there. You can donate to us. Not only that, it is a 501c3 tax-deductible charity organization. We are a nonprofit. We are a nonpartisan. This isn't about politics. This is about restoring freedom online, period. You have free speech. You should have the free market. That is what we are trying to fix right now. And we have been working on this. I mean, Jeff, what are going on? 2, 3, 4 and a half years now? We've been at this.
It's been a absolutely insane time and cost investment, and it's only going to be insanity on steroids moving forward. Vitality Law, Putterman and you, which is our California co-counsel, Jason Fick, we're in it to win it. And Jason keeps saying restoring freedom online, but think about what online is today. Mm-hmm. It's freedom straight away. Yeah. Online, that is our news. That is our modern day public square.
Right.
That is everything to most people these days, throughout the world, not just the United States of America. So yeah, he is technically correct when he says restoring freedom online, but folks, think about how much wider reaching online really is these days. It is the world.
It is. I mean, it's the first thing that people look at in the morning and the last thing a lot of people look at night before they go to bed. It's social media. It's the internet. Livelihoods, businesses are really conducted through the internet. It's the modern day, open square, like you were saying, public square. So, I mean, this is the most important case, and we are desperate in this country, especially as conservatives, to see some traction in the courts. And obviously the Supreme Court, even though they're supposed to take cases that are, critical, especially versus the Constitution, right? When in battling the Constitution and the constitutionality of certain companies, big tech here, for example, you notice and can't help but notice that the Supreme Court doesn't want to take these political cases. They don't want to take it with President Trump in the election. What are your thoughts on going forward? I know that you just appealed it in the Ninth Circuit Court, and there's a long way to go, and you don't know what the courts are going to do. But what is your hope? Is your hope to get to the Supreme Court and challenge this constitutionality of the Section 230 under Good Samaritan?
Let me just say one thing, Anna.
Yes.
You're absolutely right. We're desperate as conservatives. Let me scale that out, punctuating something Jason said maybe 2 minutes ago. Mm-hmm. We're desperate as Americans.
Right.
This is bipartisan straight away.
True. The
left, the right, somewhere in the middle, everybody should agree how important our cause is. And yes, has the conservative censorship taken a front page, so to speak? Sure. Mm-hmm. But Jason's case never was, never will be anything to do with politics. I don't know if the current administration would admit this presently, but back during the times of Biden running against Trump, Biden was in agreement too. There was an equal amount of news articles out there from Biden as there was Trump that Section 230 is royally messed up.
It's broken.
It is broken. This is a bipartisan quest. At least it should be. Absolutely. Mm-hmm. Because just as, maybe conservatives don't want their political persuasion suppressed. What about Democrats and the left?
Right.
That don't want their businesses destroyed.
Monopolization, anti-competition, economics. Isn't that something that the left is supposed to prescribe to? There's equal reasons cutting both ways as to why Section 230 has to be fixed through us now.
Yeah.
Yesterday. Yeah. So what we hope to achieve, Jason's individual case would take a huge, huge step in the right direction. If the Ninth Circuit does the right thing and ratifies its prior precedent called Enigma, which is any big techie engaged in anti-competitive animus is at the threshold, no Good Samaritan, no Section 230 immunity. That's huge. But as Jason said, there's 4 discrete levels to the immunity analysis. And that is what the prospective constitutional challenge is aiming at. Make the whole darn thing harmonious. Finally,
Right.
It has been muddled and messed up for 26 years. Now, Anna, a unique thing about a constitutional challenge is that, kind of like an appeal, it's supposed to draw 3 judges out of the gates, a panel. And last I knew, instead of having, God forbid something goes wrong at the district federal level for us on the constitutional challenge, I'm just not seeing that.
Mm-hmm.
But God forbid, there is supposed to be a fast track to the Supremes. And if we get fast track to the Supremes because the district continues to mess things up, we are very confident that this is precisely, quote, the appropriate case that Clarence Thomas was searching for. The Supremes have not had a chance in 26 years to tackle 230, and that's coming through us. Now, that's only if the district messes it up.
Right. Well, hopefully they don't. But of course, we wouldn't be surprised if it goes all the way up. And hopefully the Supreme Court will take this case, because we went through it last time, Jason and I, and it was pretty extensive. Thank you, JP. He's pulling up the Section 230 law, the code actually in there. He's going to pull it up if he can. He's trying to find it at the moment. But
I would actually inject this. The one gentleman had asked about where to find more information besides going to socialmediafreedom.org. If you want to understand this better, and actually we have updated that the executive summary that you're showing, we've updated that substantially since that point. And that is available on the website right now. You can read it. Just go down on the home page, and it's called the Executive Summary. And it basically explains in writing what we're doing. And believe it or not, that is the 15-page short version of this. It is a very comprehensive case. But that's what needed to be done. We needed to do the work. If you go to the home page on there and scroll down, there's a gentleman that is chipping away at a mountain of social media, which I think is kind of interesting. If you scroll all the way towards the bottom, you can keep going down. And there.
By the way, this video
down.
right here, and this October 13th video is where we went through. You guys can check out the latest here. Okay, keep going.
Right there. Whoop.
This one.
Right there. Revoking protection, Section 230. Okay. That is the new executive summary, and that will explain what the case is the prospective case for the constitutional challenge. It's a little bit more comprehensive. It may be confusing for some people, but we cite the laws and so forth, and we show exactly how the law was built, how it was structured, how it's supposed to function, where it's unconstitutional, and this is what we're going to be moving forward on for everyone. And realistically, this is a true fight for this nation.
It is. It is the most important fight right now. I mean, there's really nothing more important than big tech, and especially really, I mean, 230. It's not against big tech. It's really to make it fair for everyone.
Real quick, this is a great quote, and I tried to explain this to somebody because I was talking to several people, and they're like, "Well, it's not the most important thing. Election integrity." And I said, "Do you know what the truth is?" And he said, "What?" And I said, "The truth doesn't matter if no one knows it. If you don't have free speech, none of this stuff matters. Like literally nothing, because nobody will know the truth. That is the most important thing, and we're losing that right here. That's our point, is that this is effectively free speech, because online is where most people express it nowadays."
Well, Jason, if someone thinks election integrity is numero uno on the hot topics to address, what's the root of that modernly today? 230.
Yeah. Ultimately, it's still a matter of free speech and being able to converse, because they can manipulate elections. They can kill information. We've seen that. We've seen them suppress, derogatory information of one of the candidates, here and there. We've seen them also increase. They developed, and unfortunately, the courts have yet to figure out what development in part is. Just the advancement and the support of certain information is development. So promoting content to hurt a candidate is also a problem. The fact is, they should be playing a neutral realm, and that's all they should ever do.
That's right. That's right. And people have the right to share whatever they want, say whatever they want, even if it's offensive. Truth doesn't care about your feelings. It's true.
Yeah,
I love that
just
quote.
very
That's
right.
true. Really, really true. Okay, so where can people follow you? I know they can follow you on Facebook, Jason.
Well, I'm still on Facebook.
Well,
I am still waiting for that day for them to just push the button and get rid of me. And we'll take that as it is when we get there. I mean, they hit me for anything they can, but it'll make them look bad if they do it because I don't really say anything anymore. The other thing too is I am on Twitter. Yes, I am on Twitter at Jason Fick, FYK. It's pretty easy name. Find me on there. I would also suggest on Facebook, follow my profile. Rather, I don't really use my page much anymore. I've sort of given up because everything I do, I get banned for, so I just sort of stopped doing it. That's actually that'll have something to do with substantial overbreath ultimately because it deters future speech. But no, I would appreciate best thing I could say is go to socialmediafreedom.org. We have good information on there. We will continue to update that as we can, and we need help. We need your help. We can't do this by ourselves. I mean, we virtually have so far. We need other people's help now.
That's right. And people need to step up. This is we went through the case last time and what you're bringing forth with the Fifth Amendment appeal and the First Amendment as well. It's interesting. Congress is interested as well. I mean, this case has legs from what we went through last time. And I don't know much about cases, but it really hit a nerve when I read it. I thought this is unbelievable. And like you were saying, Justice Thomas also was looking for something like this. I mean, for a long time. And here we are. We have a case that is coming forward, that came forward, that you already filed and you're appealing, that has legs. So this is a way for Americans to really get involved. If you are on Twitter and you want to stay on Twitter or on Facebook, or you lost your account in both places, this is the case where all Americans, we can stand together and donate. This is where to donate. I'll be donating as well.
Thank you.
Amen. And I know I said it last time, like, I forgot to donate, but I'm going to donate right after we get off of live and donate there because, again, this is the most important case in the country. So share this video, share this information, share the website, socialmediafreedom.org. Jason, thank you for joining us again. And also, Jeff, we are praying for your case to be heard, to not be dismissed, to be heard, and if not, go all the way to the Supreme Court. But we have full faith that this year is really going to shake big tech. It's about time. Yes.
Thank you.
Yes, thank you. Yeah, it's people like you that help us and get our message out because, people say, well, why don't you put a GoFundMe together? I'm like, okay, where am I going to do that? On social media? It's the same things. They you saw what they did to Kyle Rittenhouse.
Yeah,
You saw what they did to the truckers. The scope of what has happened with this 230 has got to stop now. And thank you for helping us.
It is my honor and my pleasure to help this country that gave me so much. We love this country. We love our freedoms. We love our Constitution. We love using our social media. It's fun. It's awesome. That's where I get my news as well. And so it's a shame to see people getting kicked off, and it's about time we had enough and stand up. So this is a great cause to be a part of. It's going to be a lawsuit that we're going to be watching. And I wouldn't be surprised if you're sitting in front of Congress very, very, very soon to talk about this case. So we have it in our prayers. Amen. Thank you, Jeff, for joining us as well.
Thank you, Jeff.
Thank you, folks. Thank you so much.
God bless you. We were excited to hear an update. So whenever you have an update, Jason and Jeff, come right back. Okay?
Sounds good.
Deal. All right. See you guys. Share this video.